So the Justice Department is telling Sanford, Florida police, don't give George Zimmerman his gun back. The feds have placed a hold on all the evidence from this trial. They're looking at whether he should face civil rights charges in Trayvon Martin's death. And the Reverend Al Sharpton plans to lead what he's calling Justice for Trayvon Day. That's happening tomorrow. There's going to be rallies all over the country. It's planned for at least 100 cities to press for civil rights charges against Zimmerman. Among them, L.A., New York, Miami, Alabama, all over the place. Well, let's bring in Dan Schorr. He's a trial attorney and former prosecutor in New York. Dan, thanks for being with us. You know, I want to get to this point of the gun because a lot of people are asking, should George Zimmerman be able to get his gun back? But he was found not guilty. Now we're finding out he's not going to get the gun back, but will he still have his concealed weapons permit?
He probably will still have his permit. He had it before this incident and he was found not guilty. So there's no legal reason to take it away. As far as the federal government wanting the local police to hold on to evidence, that is standard and proper if they are looking into a possible prosecution, because if they do prosecute him for any charges related to this incident, the gun would be an important and crucial piece of evidence. So they would want it with law enforcement authorities and not back with George Zimmerman.
So there's that big question of if he is charged with civil rights charges against him. Do you think that's a possibility? Do you see it going that way?
I would say it's very unlikely because the government, the federal government here, to prove civil rights violations would have to prove that George Zimmerman committed a crime in shooting Trayvon Martin, and also he did it because of Trayvon Martin's race. They would have to prove that beyond a reasonable doubt. Based on the evidence presented at trial, in the state trial in Florida, there's not evidence showing anywhere near beyond a reasonable doubt that his actions were because of Trayvon Martin's race. Now, if there's other evidence the federal government knows about and they're going to offer that, that could change the calculation. But based on what we know now publicly and what was offered at trial, it doesn't seem that they could even come close to making that burden. And I would doubt that they would bring charges.
Well, just a few moments ago, we heard Sabrina Fulton actually bring that point up, and she said it actually does have to do with race because you heard on the non-emergency call, when prompted by the dispatcher, that he was an African-American male. There had been break-ins in the area. So her point is, well, isn't that then and there profiling based on race? If you're looking at it from Zimmerman's point of view, it's because there were break-ins in the area, and so he was extra aware. But does that reach the bar of civil rights charges? Would it have to be something greater than that?
Well, first of all, listening to Trayvon Martin's parents is heartbreaking because they did lose a child who was legally allowed to be where he was, and through some confrontation ended up being shot and killed. It's a different issue, however, whether they could actually bring civil rights charges. George Zimmerman was prompted by the law enforcement authority he was on the phone with to say, what is the race of the person you're following? And he did say it was a black person. He did call the police about other people who were also, at least in some occasions, young black people, but they would have to prove that he committed a crime, that his actions in shooting Trayvon Martin were unjustified, and that he did it because of Trayvon Martin's race. That's really hard for them to show because, first of all, his justification defense worked in the state court case, and he would still have that in the federal case. And also, George Zimmerman is saying that he used force because he had this threat of imminent serious physical injury or death when Trayvon Martin was on top of them. They would have to show that that's not true beyond a reasonable doubt, and they would also have to show that his actions were because of Trayvon Martin's race, not the following him because of race, but actually shooting him and killing him because of his race. That's a hard thing for them to prove.
As you point out, a high bar to set. All right, Dan Schorr, we'll check back in with you in a little bit. Thanks so much. So let's bring in Dan Schorr. He's a trial attorney and former prosecutor in New York. Dan, thanks so much for being with us. You know, Dan, I don't know if you got a chance to hear the president. He just spoke for the first time on the Trayvon Martin case, and he did talk about the stand your ground law. And he said if the roles were reversed, would this still hold? And this means we need to take a look at that law, and maybe there should be some reform. Do you agree with that?
I think he raises a really important issue, that the stand your ground laws are controversial. The stand your ground laws, I think there's a lot of misunderstanding about what they are. If there's an imminent threat of serious physical injury or death to you, in places that don't have a stand your ground law, you have to take any avenue of escape that you have before using deadly force. In a stand your ground area such as Florida, you can stay there, stand your ground, and use deadly force against an imminent threat of deadly force or serious physical injury, you don't have to take an avenue of escape. Now, it is important to have the debate about whether these laws encourage violence, whether they should be amended or discarded, but it's also important to note that these stand your ground laws really don't have anything to do with the verdict in the George Zimmerman trial, because his defense was that he was under Trayvon Martin with his head being smashed into the concrete while Trayvon Martin was on top of him. Whether or not that is true, that's his defense. So his defense was a standard justification, self-defense defense, that he had to use deadly force because there was this imminent threat of serious physical injury or death. He had no avenue of escape in his version of events, so it wasn't a real, true stand your ground case. However, it is an important debate to have going forward, as the president said.
No doubt. And actually, one revisions to the law that I had read about, someone had proposed, was putting in a provision that if you don't actually put yourself in the position where you would get into that argument, and you would assume that that is don't get out of the car kind of a situation. But if you don't know whether or not someone's getting out of the car to get into a fight, how do you use that in a defense if this were to be a change?
Well, generally in self-defense law, if you're starting a confrontation, if, for instance, if I run up to someone and punch them and then they attack me, I can't then use deadly force against them, even if there's a threat of imminent serious physical injury or death from them, because I started the altercation. If you extend that to just following someone or looking at someone, you're in dangerous territory, because it's going to be hard to define. Is that starting a conflict? If someone looks suspicious in an area, is that starting a conflict by following them at all? I doubt you'll see that added to the law. However, I think the president's right that we need to examine stand your ground laws, see if they encourage violence, but it really is separate from the verdict in the George Zimmerman trial.
All right, Dan Schorr, thanks so much. Some good insight there. Thank you.